anyways, I was introducing myself and to my shown that I'm teaching some of you in courses, so you know me already. For those who do not know me, particularly those who are attending the IP elective this year. I'm the director of the intellectual property unit on the 6th floor and also the director of the iNtaka Center for Law and Technology. And I'm just the greeting uncle here really today to introduce our speaker. Thank you very much for coming, first and foremost. I know it's kind of Friday in a way, so there is a Human Rights Day just ahead of us, and it's late in the afternoon. And then I guess most of us attend lectures on Friday. I don't even know if and they will not be well attended, I suppose. So from experience, anyway, so many of us actually have an extended weekend ahead of us, but I promise you it's worth your while that you're staying a little bit longer, and it's between now and 4 o'clock that I think we're going to listen to very fascinating talk. So those many of you, I guess, know that I was on sabbatical last year, and part of my sabbatical I spent in Canada at the University of Ottawa. And among many other things that I did during this time is that I attended, I want to get this right, I attended the Ian Kerr Memorial Lecture at the University of Cape Town, and the keynote speaker, Kate Crawford, did a fascinating talk as well. This is not Kate Crawford. I'm going to introduce her properly. They know each other quite well. But bottom line, the keynote speaker, then Kate Crawford, made an interesting point, and that she said that if she looks at any type of law at the moment that she believes is most threatened or most in jeopardy because of artificial intelligence, then it would be copyright law. So it's her point was really that that potentially AI is doing away with copyright because it doesn't work well with some of the core concepts. That is her opinion. Certainly, like as a copyright expert, I was like, oh, I'm out of jobs because that law will kind of fall away. But I've heard since kind of the kind of opposite opinion as well from just as well respected scholars in the field. And they are basically saying, well, it could also be the other way around. It could be that copyright is the end, could be the end of AI in a way of because of many of the challenges that copyright legislation poses to like the way of how AI really functions. So you can hold either of these two views really, or you can try to do what our speaker today is doing, to acknowledge the problems, to explore the problems, to identify the problems, but then also to go one step further. And that is just to try to present some solutions to these problems. And I think this is what she is trying to talk us through. The guest that we have here today with us is, and I read this out, you have seen this in the faculty, I suppose, but just to have all protocol observed here. Our guest today is Dr. Karis Craig, and she's a faculty member at Osgoode Hall at the School of Law at York University in Toronto, Canada. So another university in Canada. She is an associate dean there for research and institutional relations, and also the director of the law and technology program at IP Osgoode. So I always say when we work together, she is the me over there in a way. So same kind of centers that she directs at that institution. She is also the academic director of the professional LLM program on IP and editor-in-chief of the Osgoode Hall Law Journal. She teaches and researches, unsurprisingly, in the area of copyright law, trademark law, law and technology, and feminist legal theory. So the topic of her talk today is the AI copyright challenge, exploring the limits of expression and exclusivity. I'm very much looking forward to it. I know there is some talking about South Africa in the talk as well, but it's also introducing you to the global discussion in this field. We set roughly 45 minutes or so for the talk. Let's see how that goes. If you have some questions, please reserve them for the Q&A session. If you ask good questions, we have then for those who have asked the best questions, cotton candy and slushing outside, and for everybody else, really. So the floor is all yours, and Dr. Karis Craig. Thank you very much for coming.
Thank you very much for that lovely introduction. And I just want to echo the thanks for being here. I do understand that getting you to stay just before a holiday was a large ambition, and I'm very pleased to see that it has paid off and that you're here, and I will hopefully ease you into your break tomorrow. I do apologise as well that you can't really see the slides. I believe that there is an online version that you can either follow along with or you'll be able, yeah, even? Okay, perfect. So feel free. Unfortunately, I'm not maybe organised enough to just methodically work through them one by one and cover them all. So I apologise, you will be doing what I'm doing, which is working out which slides I'm talking about at any particular time, but I'll try to keep it fairly organised. And I also understand that there are different sort of levels and different acquired expertise in the area within this room. And so some of you are studying intellectual property law and you've done copyright. I've been told that you've maybe covered like authorship and originality, but haven't quite got to infringement. Others are doing law and technology. Is that right? What's the, yeah, cyber law? Okay, perfect. So you might not be copyright experts as such, but you'll have been thinking about maybe AI already. I'm going to try and bring it together, but I also want to sort of teach it at the same time. So I don't want to overrule you, but if you do have questions as I go, I actually don't mind at all. If you raise your hands or ask me to explain something or clarify or even interject with an opinion or a comment, it's actually totally fine. And hopefully we'll also have a little bit of time at the end for some Q&A before we finish for anyone who's still in the room. Can I stop and check? Like, can everyone hear me okay? I can't work out if the microphone's doing anything or not. We're good at the back. Perfect. And I apologise. Thank you. Good. For the accent, which as you can tell is actually not Canadian. Can you tell?
Yeah.
Okay. So it's Scottish, I'm Scottish, but I go undercover as a Canadian sometimes, and it's in that capacity that I'm here. So I'm going to talk a little bit about Canadian law as I go as well, just so you get a sort of comparative flavour. I'm going to pretend that I know something about South African law, but I stand to be corrected, and I'll do my best. I basically just copied one of Tobias's slides into my slideshow about half an hour ago, and that's what I know. So we'll see how well I cover that up. Anyway, let's get started, shall we? So, the rise of the machines is here, right? Everyone's talking about AI all the time. These AI robot conquerors have come to us not to take over the world yet, but right now what they're mainly doing is generating stuff, right? That's what we're talking about, is generative AI. They're generating text and images and software code, I'm told by people who know about such things, and now videos. And so they're coming to us really as creators, which is almost the last thing that you would have expected our robot overlords to be. But this is where we are. We're moving into this digital world where our own works, our own sort of artifacts are themselves capable of creating other works, other artifacts, okay? And so suddenly we're at a point where, at least superficially or facially, the works that are being generated by AI are essentially indistinguishable from human-made works, okay? And the examples here are, even a year or two ago when I started working this, actually 5 years ago, no one had really even wrapped their mind around this, at least not, it wasn't part of the public discourse, right? What could be generated by AI? But now they're almost sort of pedestrian, these examples that we see, right? So we have, with a few basic prompts, ChatGPT can spit out prose that basically fulfills the demands of any writing task that you might be assigned as students or as lawyers, but you shouldn't use it, and you know that, right? You've got to be honest about it if you do. But for the, average reader, you'd be looking at something that was generated and think it could have been written by a human author, as opposed to obviously being constructed by algorithmic code. Similarly, we have things like the images generated by Midjourney. So it's doing the same thing for visual arts, right? You just have a language prompt and it can generate an image within seconds, faster than any artist could move their paintbrush across a canvas. You have Mubert composing music from basic text inputs. You have the Sora app. Has anyone seen the Sora app videos online? I mean, they're amazing. They're like these sort of photorealistic videos that you can generate from text prompts. So all of a sudden, what we're seeing is what Dan Burke calls synthetic creativity, right? It's creativity, but it's synthetic in the sense that it's not really real. in the way that we would have understood it before, but the things that we're looking at, they're very real, right? And so we're in this age of synthetic creativity. The other expression Dan Burke uses in his article is, the title of the article, cheap creativity, right? It's easy. Everyone can make a movie of anything they can imagine in a few minutes, right? A few seconds sometimes. So it's not really surprising that in this context, copyright law, which is, of course, the law that grants exclusive rights over original works exactly like this, right? Over prose as works of literature, over software, over music, over art, that these, and drama and film, that copyright law should be having some kind of existential crisis, right? That suddenly it's like a fresh existential crisis, the likes of which we haven't seen since the arrival of the World Wide Web, right? Or what we used to call the information superhighway, when we didn't yet know what we were talking about. We really did. And the age of Napster, right? We had the same sort of copyright existential crisis when Napster first came along, when we were thinking about peer-to-peer file sharing and all your faces are blank, and I know that this is all before your time. So just trust me when I tell you that we worried then that copyright had met its match, that there was no way it could move into the internet era intact, right? And yet it did. And now here we are, another paradigm shifting technology has arrived, something that changes the way that we create, not just the way that we share our creations and disseminate our creations, but the way that we create. And the question is once again being presented, is copyright going to be able to make this move into the age of AI intact? And more to the point, do we need it to, right? Do we want it to? These are things we should be concerning ourselves with. So from a more sort of doctrinal, just like the niceties of copyright law perspective, what are the issues that artificial intelligence is presenting? So I'm going to break them down in, well, a couple of different ways. Certainly there's a slew of new issues that just require us to revisit old doctrine and to ask ourselves whether it applies or how it applies. And at the same time, when you're talking about something that brings so much value, and I don't just mean sort of cultural value, I mean more like economic value, like there is money to be made here and people are making money, the question becomes, who's going to make the money, right? And so that's when you see as well, like when you've got conundrums in the application of basic copyright doctrine, the answers that we come up with kind of determine who's going to win and who's going to lose, who's going to make the money. And there's a lot at stake. So those are the, we can look at this in different ways, like our cultural environment. What do we want copyright law to achieve? We can think about just our basic core doctrines. What do we want? How do we want copyright to work? And then we can think about the the pragmatics of it. Who do we want to win? What do we want to come out of this? Because at the end of the day, law is just something we make up, right, to achieve certain social goals. And you hope ultimately that we would either apply it or change it so that we could advance our shared social values, advance the public interest in some way, rather than let these questions be determined just by the lobbyists who happen to be around the table. Right, so that's the critical moment that we're in when we're thinking about what is copyright law going to do in response to artificial intelligence. So anyway, I said, these are the issues. So one of them is about authorship and ownership. And I think I'll spend maybe most of my time talking about that. We're thinking about, well, what about the copyrightability of these AI generated works? When AI does spit out an output that looks like a human created work, are we going to protect it as though or as if it were a human created work? Or are we going to say, no, there's something categorically different about it? We will not. Right? And so that's one of the big questions. And then, of course, if it is authored, if it is protected, who should own it? Again, that's really the who wins question, right? Because if you own the rights over something of value, then you win. The other issue is the infringement question. You could also put it as who loses? I don't know. So the infringement question, you can't read it. Trust me when I tell you, it says inputs. So then we're thinking about text and data mining is the way that we commonly refer to this. The thing that you do to train the artificial intelligence system involves a vast amount of text and data in order to generate I'm not a technologist, so just trust me, I'm just going to say things, and I don't know actually how they work either. I'm told millions, billions of pieces of text are used. The information is extracted from that text. They're essentially sort of datafied. They're turned, the meaning is turned into math. The works are turned into statistics and then tokens, and then that teaches the machine, and then the machine uses all of that information in order to generate something else based upon the probabilities and predictions that it has learned through its digestion of that information. Make perfect sense? Yeah, we could all do the main point is copyrightable works are going in and other things are coming out. Okay, so in the digestion of the copyrightable work, that input stage, is that a copyright infringement if a work goes into the system and the system is trained on that work and permission wasn't sought for it? That's another one of our big questions. Okay, and then also still at the infringement point, when it spits out something, if that something is very similar to existing works that are protected by copyright, is that going to be copyright infringement? Right, so when the AI system makes the next Drake song, and it sounds very similar to a previous song that someone has copyright in, maybe Drake, maybe not, but is that going to be an infringement? And if so, who's responsible for the infringement? Is it the AI, like it's a robot infringer, or is someone else responsible? What should we do about that? Incidentally, so far as I can tell, all of the Drake style generated outputs are much better than actual Drake. So think really carefully. If what you want is the law to say no simulated Drake, you're going to be stuck with the real thing. So, you know, he's from Toronto, by the way, if you didn't know that. The Canadians never get credit for their mediocre artists. So, okay, so those are our questions. Did I do something? Yes. Okay, so let's start then with this one. Is there copyright in AI generated works? So about 6 years ago now, I co-wrote a paper with Ian Kerr that was called The Death of the AI Author. And in that paper, we set about just trying to argue that the concept of an AI author was an oxymoron. Like, it's just not something that can happen because an AI cannot be an author. To call an AI an author is a category mistake. We're attributing to artificial intelligence qualities for which it is simply incapable by its own nature. Okay, so the way that we did that was to say, well, what we require for a copyright is an original work of expression. The reason that we want to encourage original works of expression to be created is because we value that creative, communicative act of authorship, the sort of social dialogue, the vibrant public domain that we create when we speak to one another, when we think creatively, when we exchange ideas. Machines, we said, are just categorically incapable of authorship because they have no expressive agency, because they have no capacity to make meaning, to convey meaning, because they have no real world reference to understand what it is they're trying to communicate. What they're doing is generating outputs, but not creating expression, right? Because that requires something like creative agency and the capacity for communication and meaning. Okay, so let me put this in a little bit more context. We know, for example, and a lot of research now in the AI area demonstrates that people are really inclined to anthropomorphize robots, right? And pretty much anything, actually. But we attribute human attributes and emotions to robots all the time. It's common in our cultural zone, like we know, I don't know, before you were referring to this thing that's recording the lecture as she, because it's called Polly. And I wanted to, the feminist theorist in me was about to say, are we going to gender our assistive technologies in this way? But the truth is that we do, we anthropomorphize, we often gender, we attribute characteristics to robots and technologies that they do not in fact have. And it's not just a sort of common instinct, like even amongst researchers. So researchers working on Kismet, the robot, this is going back a little while now, we talk about how Kismet showed surprise, or Kismet was happy, or showed that he was happy. And of course, it's not showing surprise. It's not surprise because there's no capacity for that emotion, right? It's a representation of a smile or the representation of a gasp that appears on the robot's face. But when we start talking about it showing surprise, we're acting as though it has expressive agency, as though it has intentionality that it doesn't have. Okay, so the point really is AI is computational. It is, I think Emily Bender in her podcast often just says, if you replace it with mathy math, you begin to realize how ridiculous half the things you're saying might be, right? We're just talking about maths and it's computational. Expression, communication, are intentional. Those things are very different. One of them requires agency and autonomy and the other does not. And this is another example, the robot dog. Anyone seen, sorry, Spot the robot? You cannot really see him here, but okay. And of course he's called Spot because we're going to say he's a dog. And you know what that makes him look cute, just a cute dog. And that's like, he's a cute dog until you put a gun on the back of his back and send him out into public protest. And then it's just like, you know, a weapon of war. And so the idea that you can achieve something from a policy perspective by attributing characteristics to the thing that make us sort of misunderstand what that thing is. That's the basis of a sort of policy mistake, right? And if you begin making policy with a misunderstanding about the thing that you're trying to regulate, that's a very dangerous place to start. And so they, you know, there was a video, it's probably a year or two ago now, of all the robots dancing to like they're doing the mashed potato or something. And everyone was like, that's so cute, the robots are dancing. Look at Spot the dog, he's dancing. Right? And so then I thought, okay, well, this is another moment where I want to issue a corrective. The robot isn't dancing. Right? The robot is moving. But what is it that makes dance dance? We say copyright protects dance and choreography should be protected. Does it protect every pre-programmed movement of everything? Or does dance mean something else? And if dance is social, if it's communicative, if it is collaborative, if it's relational, then again, it's something that robots are incapable of doing. Okay, so that's similar. If the authorship argument doesn't work, then I think the dance argument might still resonate. Okay, so that's what Ian wanted to stress about robots in all different kinds of contexts. You've got to start with the recognition of the actual nature of the technology. And so when a neural network like ChatGPT is trained in vast quantities of text and it's writing a screenplay, all it is doing is, and it's important to remember this, especially if you're studying law, because it doesn't know what an actual case is. All it is doing is predicting words that come after other words that might logically be strung together into sentences and then into paragraphs and into another. It's a language predictor model. It's not an information retrieval system. It's certainly not an author, right? It's just predicting. So as Ian said, the machine neither knows, understands, nor appreciates the connotation of its word assemblage, and let alone the meaning or value of the work as a whole. Ryan Calo also depicts it thus: the box is gorged on data, but with no taste for meaning. The other person that we've heard a lot from in this conversation is a linguist, Emily Bender. I don't know if you're familiar with her work on this, but she reminds us very evocatively that large language models are really just stochastic parrots. Right? The system is just stitching together sequences of linguistic forms that it observes in its vast training data with no understanding of meaning, and again, no world reference. It's not speaking, and if authorship is a speech act, then it's not authoring. Okay. That all might seem a wee bit philosophical, so we're just going to now turn to the copyright doctrine and see, well, what does copyright law have to say about this, or what might it say if we were to try to apply it to this generation, to this language prediction process. Okay, so in basically all, well, in jurisdictions like South Africa, I got it, as well as the UK and Hong Kong and India and New Zealand, you have a deeming provision. which says basically that we're going to deem the author of a computer-generated work to be the person who makes arrangements necessary for its creation. So what you're saying is that if you have a computer-generated work that cannot or does not have, can't be attributed to a human author, I'm going to deem the author to be just the person that makes it possible for the computer to generate that thing. Okay, so that's really just a legal fiction, where the law seems to be suggesting at least that for AI-generated works, if we think of them as computer-generated works, that we don't need to find a human author who's expressing something, because we're told by the statute where authorship lies, and it's just in the person making the arrangement. So it's not an authorial act. We have a legal solution, a legal fiction. I'm just going to say, and I wasn't meaning to land on this point, but I think it's unfortunate that this is there. Right? It was added for computer-generated works in the I think it first appeared in the 1980s, and then gradually it spread in the 1990s. And when people were excited about Microsoft, I don't know what exactly we were excited about, but anyway, it wasn't really meant for a system that learns and generates something new in the same way as a large language model or a GAN network, so a neural network. So some people say, well, it doesn't necessarily apply. And I think we're right in saying that there is no definition of computer-generated work in the South Africa Copyright Act, and if that's the case, then maybe that is up for grabs. Still, I'll tell you that in most jurisdictions around the world, and certainly in the absence of any such deeming provision, the doctrinal baseline is, as I guess it is here, that the authorship otherwise is a human endeavor, right? That an author should be a human. Let's just put it that. And so in the US copyright law, let's say, the copyright clause, first of all, of the Constitution grants to the Congress power to secure to authors exclusive right of their writings. So that right that is granted to Congress to give rights to authors is only for authors, right? And so then you have some old case law that tells us what it means to be an author. It requires an intellectual conception, and therefore it has been determined through several cases in the US going back, well, a couple hundred years at this point, that a human being must create a work in order for it to be considered an authored work, in order for copyright to attach. Okay? And so this, for example, is the famous, most recently, Stephen Thaler's application to register this AI-generated image was rejected by the US Copyright Office in February 2022 for this one, because, and that's been upheld, because it doesn't have a human author. If it doesn't have a human author, it can't be registered as a copyright work. And in the US, of course, they have this sort of quirky register, which does mean that many of their decisions about what gets protected by copyright are being decided by the Copyright Office. That's where the rules are being made on the ground, kind of in real time. Elsewhere around the world, we have the originality standard, which is the sort of baseline threshold for getting copyright. That requires a degree of originality. And from all of the different standards that we might see, they seem to imagine that that originality can really only be achieved by a human. Okay, so in Europe, it's the author's own intellectual creation, and they're talking about the droit d'auteur, right, the author's right. And so they're looking for the author whose intellectual creation it is in order to protect them or give them, recognize their right. In Australia, similarly, it's been held in a couple of different cases that works must emanate from authors. An identifiable human author is a necessity before copyright will attach. In Canada, we have a skill and judgment test, so it's somewhere slightly above the UK and the South Africa test of requiring merely labour, but below requiring creativity. It requires skill and judgment. But in any event, when we try to define that, we say, well, you need some sort of knowledge, developed aptitude, capacity for discernment, and evaluation. I don't know, but the language we use to describe it sounds like you're human. It was understood that you're supposed to be human, to have that kind of intellectual effort invested in the creation of a work. And that is currently, well, what I will insist is the right answer. This is what I just copied from Tobias's slides moments ago. I'm sure it's true and accurate. You can be trusted as the source of legal information. And so we have a low originality threshold here, I understand, much the same as the UK threshold, which is sweat of the brow. The UK pre-Europe, arguably post-Europe, we don't really know, but anyway, sweat of the brow, mere labour is enough, right? So in other words, what you're looking for is not necessarily the human creative mind behind the work. You protect almost anything with copyright, right? So an argument to me might be like, you're being very nice and imagining what authorship requires and the copyright requires authorship, but actually copyright requires next to nothing at all, right? It requires basically don't copy directly from one thing and you're fine. Then it's yours, whatever you do, right? It's very, very minimal. And so I understand that that might be, and I've written elsewhere about what's wrong with the labour standard, precisely that it misunderstands what authorship is and why it matters. And so I do think that we need to have a slightly higher standard of originality that understands what is important about authorship, about creativity, and therefore why we want the law of copyright there to encourage that creative act. I hear that even in the most recent case here, this reference to the author's mind might suggest to us that maybe South Africa is also moving in the direction of understanding that even the low originality threshold requires something that is the application of the author's mind, right? And so here I'd say, well, okay, that to me sounds like there needs to be a human to have a mind, because like machines don't have minds, right? So that suggests that originality requires a human. But wait a minute, you've got this legal fiction that says that the author can be deemed to be the person who just makes the arrangements for the works to be made if it's a computer-generated work. There's one little, let me just suggest it to you and you take this and run with it, because this is, I'm just leaving like next week, I'm not leaving here, I've got nothing more to say on the issue, but it does strike me, and I've heard it said about the UK fiction, that just because you know who the author would be if the work were to be protected by copyright doesn't necessarily mean that it is protected by copyright. It doesn't necessarily mean that the work is original. The work must be original for copyright to attach, in which case we're told who the author is. Right? But you can tell me who the author is of an unoriginal work and I'll tell you, but I don't care because it's not protected by copyright because it doesn't meet the threshold. Right, so we could say if originality in South Africa requires the application of an author's mind, a work that is merely computer generated or AI generated, in which there is no author whose mind has been applied, is not protected by copyright. So the question of who the deemed author is moot. I don't know, I'm just throwing it out there. If anyone's looking for a topic for a research paper this term, maybe that's one, I don't know. I'm going to suggest to you that the way that we answer these questions, like we can just run ourselves aground, right, on the doctrinal questions. Like, what should the law do? I mean, we're lawyers, we're trained to argue about these things. Any argument could be persuasive, right? The actual question is like, what should the law do? Should the law protect these works? And here I think we need to do this in a more purposive way. Like we have to think about, well, what is the purpose of copyright law? What is it that we're trying to promote or to encourage? In Canada, we actually have some really nice, rich jurisprudence from our Supreme Court that, first of all, did elevate the originality standard to skill and judgment to get us away from mere labour by talking about the public purpose or the policy purpose of copyright. And this is what it told us. Copyright is a balance between promoting the public interest in the encouragement and dissemination of works of the arts and intellect, and obtaining a just reward for the creator. Okay, so you have both the idea of a creator who should be rewarded and a public interest that should be promoted by encouraging creativity and encouraging the dissemination of works. That's all part of the purpose of copyright. And then I've argued as well that when you look at new technologies, paradigm-shifting technologies like artificial intelligence now, but also like, digitization, like the arrival of the internet. The way to maintain technological neutrality is really to say, well, we want copyright to continue to do this thing that we think it should be doing. What might happen is that as technologies change, we kind of have to recalibrate the law so that it can continue to encourage the creation and dissemination of works of the arts and intellect in the age of AI. Right, so what would that look like? Right. And this is where I would say, well, here too, I would not be wanting to incentivize or encourage necessarily the creation of or the generation of machine outputs. I think the purpose of copyright is to encourage the act of creativity, the act of authorship, the exchange of ideas, the drive to meaning that is part of the sort of cultural environment we want to live in, or part of our sort of democratic discourse, or what we want from a participatory culture. We want people to be able to participate, exchange ideas, and create things and innovate. And so this is the way that copyright should work. And then we should say, okay, given the way that technology has changed, what does copyright law need to do now so that it can continue to serve its public purpose? Okay. And so this is the first part. I say, let's look past the AI hype about what the system, what AI can do, and imagining that it's doing something great. Let's actually, what are the implications for copyright law? I think we should never mistake the AI for an author. The AI generated works are simply not the same as human authored works, that they should not be protected by copyright. And I think that's fine, right? They can circulate freely in the public domain. I'm not saying they have no value. I'm not saying they ought not to be produced. They don't require an incentive and they don't require a reward. Okay, so even if what we have is a sort of incentive theory of copyright, why do we need to incentivize machines to produce these works? We obviously don't need to incentivize the AI. You might say, well, we need to incentivize the AI developers to develop AI tools that allow us to produce these works. Okay, well, they have already copyright in the algorithmic code in the software that makes up the AI tools. So that takes care of that. Then what you have is like, we've often justified copyright by saying, well, you know, the costs of expression are great, but then the cost of copying are nothing. That was the crisis that we had with the arrival of digital technologies. Suddenly the copies are circulating cheaply, and now they're going to undercut them. Nobody's going to bother wasting time producing something because they can't get their money back because everything is circulating for nothing. That was the concern. And so copyright stepped in to make sure that we could limit or control the dissemination or distribution of works. But now the costs of expression are virtually nothing too. Like the actual cost of producing the works, everyone can produce the works for virtually nothing. Why do we need to encourage people to use AI tools to generate things that they can do with the push of the button and a couple of prompts? We don't, right? So in some ways, we've been free from the costs of copyright, the limits and control that copyright poses, because now we just allow these to circulate freely and people can easily use AI tools to generate works and they don't need to assert copyright over it. So I see no problem in this solution. And I actually think that what might be better is for us just to say AI works are not protected at all, or the copyright works require a human author explicitly in the Act. Okay, but there is a little, like everything in copyright, it seems like it should be an easy answer. You might know what the rule is, and then you look at human creativity and cultural practices, and you realize very quickly things are a lot messier than that. And so there's a couple of cases that help to illustrate this that you might have heard of. One is this with regard to Zarya of the Dawn. So this is a digital artist, Castanova, who applied to register a comic book, and it consisted of mixed text and visual materials. And so the US Copyright Office granted the registration initially, but when they took to, when Castanova took to Instagram to say, the first registration of an AI generated work, they were like, wait, what? So then they're like, well, we didn't know it was AI generated. And so they wrote and said that, you know, we're going to actually change our decision. The registration isn't valid. Then Castanova's lawyers argued, well, wait a minute, actually, there was a lot of work that went into the creation of this comic book. And so there was a debate about where the authorship lay. At what point was Castanova an author? And there was a long creative process involved, like writing prompts. Have people use this a lot? Like you write prompts and you get different options and you choose an option and then write more prompts. And then you gradually, they said there was an iterative process in order to get to the final images that they chose to use in the comic book. And then, of course, there was the text. And then, of course, originality is not just about the individual works, but when you select and arrange them in a certain way that involves originality, then you get copyright over the compilation anyway. Right, so the US Copyright Office was like, okay, you've got copyright over the comic book as a compilation, all the text there, the artwork, no. Right, because it's AI generated, we need a human author, no. And that's where that one ended. And, you know, people were not wholly sure that this wasn't getting to look like a bit of a sort of romantic, higher standard for the author using an AI tool than, say, when you use your iPhone, right, and take a photo. Like, we kind of act like or imagine that every photo you take with your phone is protected by copyright. How much time and effort do you put into taking a selfie, right? Or taking a quick, nothing, right? I mean, if you do, it's posing, but that's got nothing to do with it. It's like how much are you thinking about the lighting and the placement of the camera? And so that's enough. Click a button, you've got copyright. Again, our standards are very low, but now we're saying that Castanova, working with this AI tool, giving it prompts, rethinking, reworking, that's not enough. Is that a different standard for a different kind of technology? And if so, is that a problem? Just came up again with this award-winning artistic work, the Théâtre d'Opéra Spatial. And Mr. Allen had apparently experimented with, sorry, it's here, over 600 prompts before choosing the acceptable panel that he was going to work with, and then continuing to tweak different aspects that the AI hadn't generated very nicely in order to arrive at the final image. The Copyright Office again said AI generated, no copyright registration. They asked them to disclaim the pieces of the work that were AI generated. If there had been some tweaking, some work with the details that might be protected, he refused to do that. They refused to grant him copyright. All of this is kind of reminiscent of lots of other sort of doctrinal conundrums that we encounter in copyright law anyway, right? If you think about joint authorship cases, I don't know if you've looked at any of those in the copyright class. Sometimes, like, imagine you've got like an architect and a technical drafter and a person who wants their house to be designed a certain way, and they're all working in different aspects of an architectural drawing, but there's only one person who's putting the pen to paper. Now, we wouldn't say that the technical drafter who put the pen to paper is the only author. We'd say the person that contributes the original expression to that work can claim to be a joint author. So maybe in this context, people are inclined to say, isn't this like a human-machine collaboration, right? Like, are we not really seeing a sort of work of collaborative authorship? This seems to be where India and Canada have landed right now, at least when it comes to their copyright offices, which have granted registrations for AI-generated works, saying, oh, but we need a human author. Okay, but then they're like, so long as we've got one human author and one AI app, we'll grant that. And then registering, if you see like here, you can see the person's name, the co-author is the artificial intelligence painting app, registered as a co-author on the Canadian registration with an address. Like, they live there. Right? And so you end up with these sort of administrative decisions that are being made. The case law is deciding things in the US, the Copyright Office where you need registration. All of this is really very much up in the air. But what I say to you is, if an artificial intelligence cannot be an author, it can't be a co-author. You can only be a co-author if you're an author, and I think that they are not. All right, so I'm going to pause for a second. I haven't embarked upon the AI training. I can do that quickly, or we can talk about the authorship piece instead. Observations in the back? A quick piece on infringement, or?
Yes.
Correct. All right. Unless anyone has a burning question they want to raise now about anything I've said so far. Okay. I will forge ahead. We'll see how far we get on this one. Okay, so this is the other big controversy at the front end of training AI. And that is the question about whether that AI training using copyright materials infringes copyright. So here, I'm going to say, I don't think it does. And I think that's a good thing. But the law is a little bit less on my side in this one, which is to say, there are certainly copies being made in the process of training AI. Okay, and there are copies being made of works that are certainly protected by copyright. And don't forget, you don't need to register copyright. It doesn't have to be a great work of art. Every single stupid Reddit post, you know, every time someone responds to "Am I the asshole?" they have copyright in their response, right? It's everything. So when you go around scraping up all this stuff and creating a data set, and then you use that data set to train the AI, you're using copyright works. And the question that we have to really ask is whether the copies that are made in that process are copies for copyright purposes. Do they count as infringing copies? I'm coming in, again, I want to start with that policy problem. I think it could be incredibly, and we talked about whether copyright could be the death of AI, copyright could bring AI to its knees, people are saying. I think that's really true, because if we were to say definitively, oh, you need to clear the rights for every piece of text that goes into feeding or training an AI system in order for it to be a lawful tool or something that can be lawfully deployed, that's going to be, I'm going to say, completely impossible, right? I mean, has anyone ever tried to get the rights for like one thing, right? When you use one thing, you have to find the author, find out who the owner is, ask for permission. See, if you, the idea that you could do this 1 billion times over for the OpenAI training, like it just isn't possible, right? That's not going to happen. But also, I think we need to think about that process that the machine undertakes as being one that, first of all, you might say is more like learning, data extraction, information extraction. Copyright doesn't protect data, it doesn't protect information. And so that should be, I argue, a non-infringing activity to begin with. And to the extent that what you're taking out are the things that copyright doesn't protect in the first place. The machine isn't using the work for its expression, it's using the work for the data, the information it contains, the patterns it contains, and those are not things that copyright should protect anyway. And I think that's good, or else we'd be in a lot of trouble. The reason I say the law is against me in this one is because the law is against me in this one, which is that basically until now we've just been like, a copy is a copy is a copy, right? And we did that when we moved into the internet era, and we worried temporarily that digital copies were being made at such great rates and so easily that we couldn't treat every copy as a copy anymore. So we created a couple of little exceptions for things that were like temporary reproductions and technological processes. But at least in Canada, we have a pretty clear case that says even incidental copies made when you're broadcasting something, those copies count. And the only question is, what are they worth? Right there, we might say, okay, well, millions of them are made, so each copy is not worth that much. But like the fact that it implicates copyright was accepted by our Supreme Court in this terrible judgment, where they cited me in the dissent. So unfortunately, it didn't win the day. And I think the majority was just wrong. But it's hard to argue anyway that copies are not copies. Except I think that you can say, as I suggested, maybe the use is functional, right? Functional uses of functional elements, information data shouldn't actually count. The use is de minimis. There's only one, like it's a whole copy of the thing, but also by the time it's translated into tokens and so on, and then included in a data set that contains billions of them, it's essentially, it should be illegal, who cares, right? No big deal. Also, you could just argue as well that actually this is going to upset the copyright balance by really limiting the development of a new technology, and copyright law ought not to be doing that, ought not to be hampering the development of the technology. It should apply equally across different technological fora, and therefore it shouldn't be so intrusive in the realm of AI. What I want to do is instead just turn around and say the same thing I said to you before. I tend to agree with myself, so it's good. So I said before, you know, like the reason we care about authorship is that what, you know, copyright is really about rewarding people who are encouraging people to create and exchange meaning to others, right? That this is part of a sort of social dialogue, like a cultural conversation. And so just as the AI cannot be an author, my argument is that the AI is not a reader. Like the AI is not an audience, the AI is not receiving a work the way that it was intended. There's nothing about what the AI is doing with the work that equates in any way to the way that we consume cultural works when we engage with them as consumers, as audiences. And so it's not a use that should count as use as a work. If you're doing trademark law, you know, we talk about use as that trademark is really important. I think in copyright law, we should be talking about use as a work, use as original expression. Is that what this is? My answer is no. And so I think that for the same reason, this kind of background, non-expressive, non-consumptive use of copyright works should be considered non-infringing. And I don't just mean that there's an exception, I mean non-infringing as in doesn't implicate copyright, copyright should not care. All right, so there are exceptions, I won't read you through those. What I think I'll conclude with is this final point, which is something that I'm working on now, which kind of brings this together. Like what I've said to you is copyright shouldn't attach to the works that the machines generate because it shouldn't care about those works. They're not works of authorship. I also said copyright shouldn't concern itself with the training of AI, right? Because that's not the use of works as works of authorship. And so that's not copyright's business either. What I'm really saying to you then is that this has got very little to do with copyright law, right? Like I think and agree, one of the slides I just skipped past, but you'll see is like for some of the cases now, if an output is similar to another work, because there was copying of that other work, copyright will deal with that the way it always has anyway. That's just substantial similarity. That's the creation of an infringing work. But when it comes to the technology, what it's generating, how it's being trained, I just think copyright law should recognize its own limits. Right? And so what I'm suggesting is that when people are talking about copyright law in this context, especially when it comes to the training data, and saying, oh, artists' works and painters' works are being used to train AI, and then the AI is competing with them in the marketplace, and that's unfair. Yes, it's unfair, but it's only unfair in the same way that I'm going to say capitalism is unfair. It's not nice, but it's also not something that copyright is well equipped to address. What copyright would do, I think, in this context, is it would actually allow for the propertization, the commoditization of large data sets so that the big players can easily enter into license agreements for vast sums of money with New York Times, for example. So then you're going to have like OpenAI is going to have a quality data set because they can afford to buy the quality data, packaged, pre-packaged, owned, and exclusive to them. But you're going to end up with an AI space where you don't have enough competition, you don't have small players, you can't enter it easily because you can't afford those big training data sets, right? So then what do? You design around it, you use public domain data, but that's going to be things that are less quality, things that are older and not protected by copyright, things that make the systems less good and perhaps as well more biased, a little bit less inclusive. So I'm worried that if we use copyright here, we're going to end up with a very different AI landscape and one that will be perfectly fine for the big industry players, the big corporations who are moving in the space, but one that will be very bad for the rest of us. That it won't serve the public interest, it won't be ethical, it won't be responsible, it'll be trained on poor data sets, there won't be transparency about what it's trained on. It's going to really hamper the development of inclusive artificial intelligence. I think rather than thinking about exclusivity and how we can put up walls and keep people alive with copyright concepts, we should be thinking about inclusivity and how we can make sure that we have the best training of AI, that everything is open and transparent, that it is accessible to other developers. And so that's what we should be aiming for. Who should be in the data set? What should be in the data set so that we're not narrowing our worldview, reinforcing the status quo, and basically benefiting the big players. So when we talk about copyright here, my sense is it's a trap. We're being wooed into thinking about copyright as saving artists, saving the cultural industries, but in fact, I think it's going to do more harm than good. And we also should always remember that copyright law is really just one little corner of this whole world. If copyright thinks it should be the rules of the game for all of AI, right, not just generative AI, but all of AI, then I think it's mistaken. That's just the hubris of copyright. We saw it with the arrival of the internet age, and I believe we're seeing it again. All right, so that's me at time. exactly, with no Q&A, I apologize. I'm not going anywhere, but you might want to, so I'm happy to take any questions, but I'm also happy to let you go and free you up for the weekend.
Thank you. Okay, I know it's 4 o'clock on the dot. Let's see whether there's any burning questions, because I don't want to let you off the hook so easily. So if there is any question, you raised a couple of very interesting points. So I think I know it's on the dot. You may have to go somewhere else, but let's maybe get 1 or 2 questions quickly, and then I'll really.
Okay, copyright aside, let's say, so there's a AI that can generate, let's say, a photo, right? And then I found an AI that takes away, it can have a logo. So let's say the AI is called Tony AI, and it makes a painting.
Okay.
You can find AI that takes off Tony's logo from that painting.
Yes.
So that aside, what are your thoughts on if Tony wants payment for you using his AI generator, but then if you don't pay, he wants his credit on the generated work.
Right.
What are your thoughts, I guess, morally or economically on removing that logo and then just using it since it's so easy to reproduce?
So this is where I have a lot more faith in trademark law than I do in copyright law. And there are moments where I'm like, because for me, trademark law, if it's applied properly, and it's not just about helping the powerful players, it's about communicating the truth to consumers, right? It should tell the true story about the thing. I actually think that Tony, leaving him aside. So I think the ability to remove a mark, to change the thing is more controversial, because I want people to be informed about what it is they're getting. And I would even go further and think that I think maybe the answer to all of this is that we actually make clear when something is AI generated, so that consumers and audiences can actually choose whether they want something by a real artist, a real author, a real human being, or if they want something that's AI generated. So I would stick to it's got to communicate the truth, and if it doesn't, that's a problem. And trademark law or certification marks or rights of publicity are going to be more helpful in this context than copyright law.
Any other questions?
No one wants to be unpopular. So
No,
probably making the right
all questions answered. So thank you very much for making time, for sharing this with us. Has an intervention in the back.
One was typing in the chat and question.
Oh, good.
Okay, yes.
So, this is a question from Jay. Should the models themselves be open source, assuming you're talking about the AI models? And what are your thoughts on regulation under the UDHR Article 27 and the ICSPR 15, which protects the material and moral aspects of creations and guarantees access to science and cultural invention?
Yes. Okay. Thank you. Two little points. So on the first one, I think yes. My answer is yes. I like open for everything. I think the more transparency, the more open, the more competition, the more capacity to evaluate and choose. Again, it's that sort of knowledge thing. So yes, I like the idea of open systems, and I'm very worried about the proprietary nature of the way things are going, both with the AI models themselves and then now the training data too. On the second one, yeah, I mean, we always run into this, like the contradiction between protecting material moral interests and protecting access to the benefits of scientific developments. And this is another place where you see that tension playing out. But I would say, and what I usually say about that is there's nothing about those human rights that require copyright to be the thing that creates the benefits or protects the moral and material interests. And so I don't think that gives us an answer. I think it sets up for us the question, the kind of policy balance that we've got to engage in. And we should be doing that with a view to the human rights are implicated and the importance of access to the benefits of technological innovation as well. Okay.
Amazing. Let's conclude. I have 2 tokens of appreciation for you. First of all, for coming down here and doing the talk. First of all, our book. It's kind of on the topic. And for free online. And secondly, a waffle. So that you don't have to queue, but also to show everyone. Okay, Sashi, you have done the work for the day. Thanks for coming. Please keep an eye open for future iNtaka sessions and have a good long weekend. Thanks.